Hello, my name is Amanda Phelan. I'm a professor of ageing and community nursing in the School of Nursing and Midwifery, Trinity College, Dublin, Ireland. Today I'm going to talk about building a comprehensive safeguarding structure for adults at risk. This is based on work I've recently completed on behalf of the Department of Health and with Mazars. We'll start by a brief look at the evolution of elder abuse. Elder abuse was first formally identified in 1975 when two separate publications occurred in medical journals reporting about physical abuse of older women and using the titles granny bashing and granny battering. From this, it became more and more of a societal issue, although it didn't gain the same recognition as child abuse or domestic violence. Elder abuse as a term is commonly used in terms of describing violence against older people. However, in recent years, safeguarding older people has been common in Ireland and the UK. Elder abuse itself is part of the context of interpersonal violence, the other aspects being safeguarding children and domestic violence. Since elder abuse was first identified, theories have been developed to try to explain why it happens. These have been based on areas such as caregiver stress, an exchange theory, revenge theory, and wider aspects of theoretical development, which include an ecological approach which can account for many factors in the perpetration of elder abuse within the ecological theory. Recent years have also seen a turn to human rights-based approaches as a lens to benchmark safeguarding and to argue for issues of equity and equality. We have also recognised the diversity of elder abuse in terms of the influence of culture and indeed the influence of gender. In the prevalence studies undertaken on elder abuse, we can see it's mainly occurring in the community setting, and also the main perpetrators are family members. What we know is the need for robust prevention and intervention responses in every country around the globe, and this would be assisted by legislation which supports a safeguarding agenda. If we briefly look at the types which have developed within the literature in relation to adults at risk, we can see there's physical abuse, psychological emotional abuse, sexual abuse, financial or material abuse, organisational abuse, neglect, self-neglect. And the question mark on self-neglect because some jurisdictions do not see this as a part of elder abuse. Discriminatory abuse, online or digital abuse, human trafficking or modern slavery, and you have social abuse, for example, restricting a person's visits with family, isolating them, resident-to-resident abuse, abandonment, and chemical or medicinal abuse. A common definition which is used in the literature has been developed by Action on Elder Abuse and is used in the World Health Organization. And this looks at abuse as a single or repeated act or lack of appropriate action occurring within any relationship where there's an expectation of trust which causes harm or distress to an older person. However, this definition is limited. For example, the abuse is defined by who does it. So if you were hit by a stranger and you're an older person, this is not seen as elder abuse because there isn't an expectation of trust. And also, if the abuse doesn't cause harm or distress, then this definition would say it is not abuse. In Ireland, there's been quite a lot of work undertaken in recent years on elder abuse. Our first policy document was in 2002, Protecting Our Future, which promoted an intersectoral approach to elder abuse. However, in 2014, the national television broadcaster broadcast a programme which demonstrated the abuse of people with intellectual disability. At this point, the elder abuse policy was transformed to include people who were adults at risk. This means that any adult from age 18 is now included under the Adults at Risk policy. Safeguarding Ireland, which is an umbrella committee which promotes the rights of adults at risk and also targets raising public awareness on abuse, and the Health Information and Quality Authority, which is a regulator of health and social care services, produced guidance on the human rights approach in health and care services. The Health Information and Quality Authority, or HIQA, also undertook some work in terms of looking at the background document to support the development of national standards, and in 2019 they produced the national standards for adult safeguarding. Other work has been done by the Health Service Executive. For example, colleagues in University College Dublin undertook an adult safeguarding legislation and policy rapid realist literature review on behalf of the Health Service Executive. And more recently, the Irish Law Reform Commission looked at a regulatory framework for adult safeguarding in a consultation paper published in December 2019. However, I'm going to focus on work I've undertaken for the Department of Health, which has just been published in association with Mazars. And this was based on an evidence review to inform development of a national policy on adult safeguarding in the health and social care sector. And we looked at 9 countries. So we looked at Ireland, England, Scotland, Wales, Northern Ireland, Canada, Australia, Norway and Japan. Based on this review, I'd like to look at these areas: terminology and definition, recognition that this is an issue in society, a turn to a rights-based approach, legislation which is specific to safeguarding, and also capacity legislation, regulation, policy which looks at preventing and intervention in elder abuse cases or adult at risk cases, and training. So terminology. Vulnerable adult has been a commonly used term when elder abuse has been discussed. However, recent years have seen a question whether this is suitable. Vulnerable is perceived to imply a dependency and targets the individual rather than looking at what is happening within that situation, rather than looking at, for example, gender, power relationships, physical or mental health status. What has emerged is the term adult at risk, and this has been used in England and Wales under the Care Act, in Ireland and in Australia. Who is an adult at risk? Well, an adult at risk is a person who is over the age of 18 and needs help to protect themselves from harm at a particular time. Distinction should be made between an adult who is unable to safeguard him or herself and one who is deemed to have the skill, means or opportunity to keep him or herself safe, but chooses not to do so. So the point here is that being an adult at risk can actually happen at a particular time in somebody's life, for example in bereavement, or it may be due to, for example, having a intellectual disability or having, for example, dementia, and that it recognises the distinction between people who do not have decision-making capacity and people who do have that capacity but are not motivated at that point in time to self-protect. In terms of an issue in society, we know from various prevalence studies that this does happen. So we need to raise awareness both in professional and in societal levels and educate people to prevent it and respond early and have a zero tolerance. Within the 9 countries we reviewed, here are prevalence studies in 4 of them: Ireland, Canada, United Kingdom and Norway. It identifies the sample size, but if you look at the age group, you can see that they're not directly comparable because the age groups are slightly different in every country. Ireland has the lowest form of elder abuse at 2.2%, as opposed to Canada at 7.5%. And you can see the most common types of abuse differ also within countries. So, for example, in Ireland, financial abuse is most common, and that's also true in Canada. However, in the United Kingdom, it's neglect that's most common, and in Norway, it's psychological abuse. The turn to rights-based approaches is based on compliance with the United Nations Universal Declaration on Human Rights, the Convention on Rights of Persons with a Disability, and the Istanbul Convention. Many policies or regulatory bodies have generated a rights-based approach through principles of safeguarding, which reflect the ethos of human rights-based approach. For example, in Australia, the principles of safeguarding include independence and freedom to participate socially and economically, dignity and choice, standards of living and care, participation and self-fulfillment. In the UK, the principles are based on empowerment, prevention, proportionality, protection, partnership and accountability. While here you can see in Ireland, the principles of safeguarding are fairness, respect, equality, dignity and autonomy. You can see how they're applied in each of those cases there. Legislation. In our review of the countries, we found specific legislation in Scotland, England, Wales, Nova Scotia, Quebec, South Australia as examples. And what legislation does it enshrines rights-based approaches and has an appropriate focus on the person and also informed consent. Legislation also frequently directs who has prime responsibility for responding to suspicions of abuse of adults at risk. Also, some legislation includes an entitlement to independent advocacy, for example in England and Wales, and for example in Victoria in Australia. We can see in more recent years focus on deprivation of liberty, and this term has been changed to liberty protection safeguards. This is particularly important when you think of the context of families having an entitlement or perceiving they have an entitlement to admit their older person into long-term care, and that older person, despite demonstrating capacity to decision make, is not allowed to leave that. So their liberty is deprived. So this is a protective mechanism to protect against scenarios like that. Legislation based on capacity is fundamental, and all of the countries had some sort of legislation which would look at how decisions would be made in association with the individual. Interestingly, in the UK, the term that's used is that decisions are made in the best interests. And while there is guidance in terms of defining best interests, when the Law Reform Commission in Ireland looked at this, they decided to use the terms decisions should align with the person's will, preference, values and beliefs. And capacity legislation can also encourage advanced planning, for example, an advanced care plan and power of attorney. Substitute decision maker, that term has caused some debate because substitute implies that that person has autonomy to make that decision, but doesn't always mean that they have recourse to follow the will, preference, values and beliefs of the individual. Instead, the term assisted decision maker or supportive decision maker firmly places the decision making with the individual who lacks or has problems with capacity, rather than seeing that this substitute person can make any decision that they feel is merited. In Ireland, our legislation through the Assisted Decision Making Capacity Act of 2015 always states you start with the presumption of capacity, and capacity has to be disproved through a functional approach. A functional approach to capacity means the information is given to the individual, the consequences are explained, it's given in a format that the person understands, and the person is allowed to think over each of the consequences and the decisions, make that decision and communicate it back to the professional. Guidance is also available in some jurisdictions. For example, in Japan, the municipalities are tasked to provide guidance if people approach them in terms of being abused. Legislation can also direct the promotion of interagency cooperation and collaboration and the mandated cooperation, so that somebody cannot say no, an agency cannot say no to the provision of relevant documents and assistance. Mandatory reporting is something that is debated globally. Within the countries we looked at, permissive reporting would be present in Australia, Norway, Japan, Northern Ireland, British Columbia, for example. In other jurisdictions, we have partially permissive reporting, where it's primarily permissive but mandated in respect to the vulnerable adults. So, for example, in Ireland, the Criminal Justice Withholding of Information on Offences Against Children and Vulnerable Persons Act of 2012 mandates that professionals are obliged, they don't have a choice, to report abuse in the context of children and vulnerable adults, particularly related to sexual abuse. Mandated reporting is available in England, Scotland, Wales and Quebec, for example, under professional codes of conduct, while Nova Scotia mandates reporting under the Adult Protection Act. As I said earlier in the Irish example, there can be mandatory reporting of sexual abuse of adults at risk, withholding information on offences against the vulnerable adult, or not reporting a serious criminal offence. While this is legislationally bound in countries such as Ireland, for example, Norway, it's at policy level. It's advised, but there isn't a legislation. And then we have some countries that have a hybrid. For example, in Canada, some of the jurisdictions would say you are mandated to report in residential care. However, outside residential care, it is permissive. That means that the person has an option to report it. They're not mandated to report it. In terms of regulation, Health and Social Care produce guidance and standards, and these are really benchmarks for care provision so that you have a good quality of care. A lot of these integrate human rights-based approaches and also have a person-centred ethos, which is closely aligned to human rights. The regulation provides for consequences, often supported by legislation, where facilities, if they don't comply, can be deregistered. Therefore, they have to close down. Or if there are concerns that there are conditions attached to remaining open, that they must address those conditions and comply with the regulations and standards. And regulation allows really a benchmarking, but it looks at individual actions and organisational systems, because systems of care can inherently be abusive. So, for example, if you have a very rigid system of care where everybody has to get up at the same time, there's no choice in what clothes they wear, there's no choice in what they eat every day, all of this actually is abusive in terms of the system of care within the facility. And again, we have professional regulation where if there is concern about abuse by a professional, they can be reported to their governing body and be subject to a fitness to practice inquiry. And many of these professional regulation bodies have a focus on protecting the public. Policy provides guidelines for what should happen. Many have legislative support, so that you have prime legislation which is transferred into how you operationalise responses to abuse of adults at risk. Generally, policy will define what the abuse is and what the service response is in terms of who is responsible for the service and the accountability. You can have principles, as I stated before, identified. The steps of what are you to do are generally identified, and it's tailored to the organisation. So organisations themselves produce how that works within their organisation. And essentially what you're looking at in a policy is who do you go to, what has to be done, where the referral goes, and when, in terms of a time frame. So something must be done within 3 days, for example. So when you've that policy, staff must follow it. And you can also use this as a quality benchmark, so people can bring any queries or concerns to, say, an ombudsman or to management of that facility when the care falls short of what is expected within the policy. However, one of the areas which is predominantly lacking in a lot of policy and indeed legislation is a focus on prevention. So generally the policy will talk about intervention rather than prevention. So we need more focus on prevention. Lastly, I'm going to look at training. So training needs to be provided for anybody who has exposure to adults at risk. So they're health and social care services, financial agencies, police and legal system, voluntary agencies, etc., etc. And the education and training needs to be at different levels, because you have people who have more specialised interaction which require detailed knowledge and understanding. So you can see here the Scottish Government produced this template for 3 levels regarding training, and you can see that at the bottom of the pyramid, awareness raising, basic knowledge and understanding. But as you go up, more and more increased breadth and depth of knowledge is required to be able to, for example, investigate the cases and make judgments and collaborate with other agencies. So the bottom of the pyramid tends to be recognise something, there's a suspicion of something, and refer on to more specialised safeguarding services. And equally here in 2018, a number of regulatory bodies and professional bodies came together and they provided training guidance for healthcare professionals. Again, you can see that there are different levels depending on the generic nature of care delivery or the specialist roles in terms of named professionals or designated professionals. And also, interestingly, they added that people who are at board level should also have training and education on abuse, and that includes private, independent and charitable healthcare and the voluntary sector, as well as statutory providers. So this is my this is my presentation for you today. If you have any questions, please feel free to contact me at this email or give me a phone call. And may I wish you a very successful conference. Thank you very much.